All right. So welcome everyone to week 6. We're looking at chapter 5, courts and sentencing. So I have the whiteboard page open, but I also have the textbook open, and I want to show you something that I think is useful to all of you as well. For emphasis, I actually have not really used the learning resources much. I've used it to make sure that I'm on track, but I do take my own notes. But if you are interested, our textbook, so obviously when we click text, that's how we read the chapter itself. But if you click on learning resources for a chapter, these are the objectives for that chapter. So by the end of 5.1, you should be able to describe the structure of the federal court system, which we've talked a little bit about before already. But if you're interested, you can actually download a copy of the presentation that the author of the book put together. And it is actually like notes that you would see in a different type of class where they would have, here's this PowerPoint slideshow of all the notes. So if this helps you better visually looking at notes and everything, I highly encourage downloading or even printing off a copy of the notes. You can also use InWeb looking at the slides as well. It runs through Google Slides. So I do encourage you to use these tools. There's also key terms here. Hint, hint, this is where I get ideas for things that need to be definitions. So yeah, in general, like I said, I don't use this too much when I'm developing content. I'm reading through the chapter. I'm using supplemental stuff, like actually fact checking and finding out what exactly PA does compared to just general. And I also, I use this as a resource to kind of go back and make sure that I'm touching the things I need to touch upon in our lesson. So, in general, I wanted to show you that learning resources thing. I had mentioned it way earlier, and I said, please use it. But after the midterm exam, I feel more compelled to be like, hey, use these resources. They are available to you. All right. In general, I'm actually going to start off with a shape, and you should be familiar with this by this point. We're talking about our court system. This is really the hierarchy of courts, and we have talked about this before in a previous lecture. How the system of government, how our courts are broken down, are into different tiers in like a pyramid-like shape. So obviously, at the very top, we have our Supreme Court. And again, I'm going to apologize as always. My writing, I'm doing this with a mouse, so not the most perfect. What I really need is one of those boards that I can plug in and write with a pen. Anyway, so for the federal system, obviously our Supreme Court is the top. And then we have our appellate court, which we've talked about before, the Court of Appeals. I should have done appeals, but ELLATE. So next level down is the appellate courts, the appeals court, and then we have at the bottom level for federal, we have district courts. And if you remember from previously in the chapters and what we've talked about, in the United States at the federal level, our district courts, there are 94 of them. Wow, that was a not great start to that 9, but it worked out. So every state of the United States, as well as several of our territories, are broken into 94 total districts, and each of those districts has their own court system, and things that are solved at that level but are not quite satisfied go up to the appellate court, and things that are still not handled there tend to go to the Supreme Court. So that's our federal level. Like I said, we've talked about this before, so this is really just kind of going over things in our... The heck with it. I'm sorry. I'm going to type it here instead, and I'm going to change the text to blue. just to have a difference. So for the state level or the lower levels, so at our top level, we have the Court of Appellate Jurisdiction. We have general jurisdiction, and we have lower courts. And so this is the system, or rather, this is the breakdown for the local, or not local, the state levels. Obviously, in PA, we have, as we've talked about before, Commonwealth Court. These are the three broad designations, but there's obviously subsets depending on particular state run. So ours is a little bit different. But at the top, our top appellate jurisdiction is the state Supreme Court. So we do have a Supreme Court still at the top. That is an appellate court. And then, as we go down, we have in some states that don't have a state Supreme Court, they, sorry, let me rephrase that. In states that have a state Supreme Court, most of them do, but in some cases they also might have a secondary appellate court, which is just simply called the intermediate court, and that really is it is an appellate court just above the general jurisdiction courts. That way, it handles issues that the state Supreme Court doesn't need to handle. They should really be handling the most important or the most impactful cases. So that's why it's like at the federal level, it's these three large, broad categories. These broad categories break down to a lot smaller at the local level. Excuse me. The general jurisdiction courts, these are courts that can hear felony cases. They're more formal and professional than lower courts, which we'll talk about here in a second. And a majority of these cases end in some kind of plea bargaining, as we've kind of talked about before. But the general jurisdiction, these are also referred to at the state level or the local level as district courts or circuit courts. So these are the ones that, they're part of the district. It's a weird, bump in the pyramid. And then the lower courts, regardless of what the names are, these change really state by state, legislative by legislative. It varies, but it's just commonly known as the lower courts, which is why I've used that term since the beginning, so that you had an understanding that it's not that they're lesser, it's just they're the bottom of the pyramid. This is the common term that's used to talk about them, even though they have a bunch of different terms. This is traffic violations and misdemeanors only, or not only, mostly. Obviously, they can handle some more serious cases, but they tend to be you get a fine, a slap on the wrist, or you go to jail for less than a year. So they can deal with preliminary matters on larger criminal cases, but like I said, typically tend to be misdemeanors. So these are more informal courts. These are things that might not even have a defense attorney or anything really. The lower courts range. This is also where we have those specific courts like juvenile court, family court, things like that. They're all part of that lower court. And so, again, this is stuff we've already talked about. None of this that I'm showing right here should be new. This is stuff that we have talked about before. We've addressed it in class, and it's, in a sense, been on at least a quiz, if not the exam. Maybe not with a visual, but it's here. So, like I said, we talked about this before. PA has, remember, the Commonwealth Court, which is an appellate court as well. It's up in this weird area. But at the federal level, so the district courts is the lowest one for them. This is the quote-unquote, as our text puts it, the workhorse of the judicial federal court system. This is, every state has at least one. They deal, according to the data, drug offenses are their largest percentage of their actual cases, which comes out to about 32% of all criminal cases. Obviously, the other big ones are immigration, fraud, and firearms related crimes. That's not to say there's not other crimes that they deal with, but those are the big ones. But it's important to note that as our changes on marijuana charges develop and redistribute and are reevaluated at the federal level as well as the state level, that drug charges percentage is going to change. It's already seen some changes, but it's going to continue to change the more we address and modify marijuana charges. So it'll be interesting to know what the percentage will be after. Let's be honest, eventually marijuana will be federally protected legal. It one day may not be in my lifetime, but it'd be interesting to know what that percentage would change to. All right. Excuse me. Like I said in my intro video, I am sick at the time of recording this. I've been sick all weekend, and I'm going to be sick much into the actual week of week 6. So if I cough, just want to let you know that it's not COVID. It's just a wet cough that I picked up virus-wise. So forgive me when I cough. It'll be a little hoarse sometimes. All right. So at the appellate level, the U.S. Court of Appeals, this is exactly what it sounds like. It's mostly here to hear the appeals of district court decisions. And that's important to remember that appellate courts, which the Supreme Court is one of them, it's just the highest, their main goal is to hear appeals. If you didn't like the outcome, if you thought that justice was not served, you can appeal to have it heard again. So that's what appellate courts are for. So typically judges at the federal level sit in a panel of 3 judges, and on rare cases and important cases, it may be all of the appellate judges, which is called en banc. For anyone wondering, it was a term that was used in our textbook. En banc, B-A-N-C. It's the same concept as en masse. It's pretty much everyone on hand addressing a particular issue. And so again, that's a term that's used with the appellate court when we have not just groups of 3 listening. So that's something in my describing of it. I'm definitely not doing a great job. So let me reiterate what I'm trying to say. At the appellate level, if you take a federal district decision and take it to the appellate courts of the United States, there would be a group of 3 judges that would hear your plea, look at your case, and determine, is it constitutional and needs to be reevaluated, or was the sentence constitutional and appropriate and upholds the sentencing? So typically, you're looking at a council of 3. In rare and important cases, like big ones, that's when you have this en banc, where it's all of the judges that are at the appellate level will sit in and weigh in. So that's just a distinction. Like I said, I didn't explain it perfectly the first time. Anyway. And then, again, still going over stuff we've already talked about, the U.S. Supreme Court, it's a limited number of people. They only hear a limited number of cases per year. They really make wide-reaching decisions. We've talked about it several times already this class. Excuse me, only because it is relevant. The Roe v. Wade overturning decision, and even the original Roe v. Wade decision, that was a Supreme Court decision. So that's an important piece to note. Like, these are the big ones. These are the top. This is the Master Court of Appeals for federal and state courts. So even if you go through the process at the state level, you can technically take it all the way to the Supreme Court. Same with at the federal level. Now, the thing is that the Supreme Court has a particular power. We've talked about discretion, and Supreme Court has a type of discretion, and it's a term that's used in the textbook. I'm going to write it before I say it because I'm going to mess up how I say it. A-R-I. Certiorari. It's my best pronunciation that I can do right now. This is the power that lets them decide what cases to review and which ones to pass on. certiorari literally means to certify. This is the power that the Supreme Court has to go, okay, we've been given, let's say in theory, 1,000 cases to look at. We can't look at all 1,000, so we're going to look at these 10. These are going to be the 10 that we look at because these things seem to be the most important. The rest we can pass on. That's their allowed level of discretion on what cases they can and can't do. And so, again, because they're appellate in nature, most of them tend to be appeals, much like the Roe v. Wade repealing was an appeal. So, yeah. At the end of the day, and these are terms that will show up and we've talked about before, or rather, we haven't talked about them before, but affirming or reversing decisions. And that's what an appellate court does, is they either affirm, which just means to agree with, confirm, this is, we hold that what was done already is correct, and that's what we're going to go with. And then obviously, I hope you can understand what reversing is without me going over it, but it's going against. So these are the two things that an appellate court and the Supreme Court particularly do, is they look at a sentence given from a lower court, doesn't matter what level, and they either affirm the decision or they reverse the decision. And so just to kind of emphasize back to the Supreme Court, because they deal with such limited cases, they tend to focus on cases that have wide-reaching, huge impact on not just one group, but pretty much the whole of the nation. This is why civil rights went there. This is why gender rights, marriage rights, all this stuff ends up going to the Supreme Court at some point because, well, that's what they're trying to talk about, is these rights for multiple people. So whether you agree or disagree with it, it's important to note that this is the system that we work in. This is the system we live in. If you're disappointed with something and the way something is turning out, remember that this is the top level. If you can get there, hopefully a change can happen. But we've talked a lot about Supreme Court in particular with the Roe v. Wade decision. So we're not going to dive too much more into it. I think we've talked about it a decent amount in our discussion boards as well as our lectures. So if you're passionate about it, and I assume I'm not the only one, I know you want to continue talking about it, but we have to move on. All right. So one thing that our textbook does here in section 5.1, one of the things that they say, I want to emphasize, and it's problems with the courts. The phrasing is kind of a misnomer, and I wanted to emphasize it's what our author is talking about is a problem that is within the court structure itself, and that has to do with the high volume of cases. Excuse me. Because there's such a high volume of cases that our justice system is dealing with, it creates a backlog. And anyone that's familiar with any kind of bureaucratic work or a 9-to-5 job, you're familiar that sometimes things don't get done. Sometimes there's a million other things that have to be done. And sometimes you get so far behind that you know you're never going to catch up. This happens. And this happens in our justice system as well. So, because of these issues, we see that courts are almost always behind on hearing cases. There's obviously, hopefully, things that we can do to change that, and so that's kind of what our textbook is talking here with the problems with the courts. But one thing that our author does bring up, and I think is important to at least emphasize here as a good example, the strict crackdown on drugs increased cases, and that forced a backlog. So when we got tough on, marijuana charges as well as cocaine, heroin, meth, like when we got serious on drugs and just started arresting and processing everyone, that created a huge backlog of cases that might have been equally as important, but they get lost in the sea of a million different things. So the question here, and our author even says, what's the solution? Well, our author doesn't say this question. This is my question. What's the solution? How do we deal with backlog? How do we deal with high volume of cases? And so our author does bring up two things that are actually already in place that the goal is to help reduce these, but we'll talk a little bit about this. So one solution is to reduce caseloads. And how do we do that? Well, they created a drug court specifically for drug crimes. So they even went as far as nonviolent first-time offenders would go through treatment or rehabilitation rather than simple incarceration, which data suggests works better than just incarceration. So we'll see. But obviously, I ask a hypothetical question. In reducing caseloads, how do we do it other than just making a drug court? Like, what other courts do we need to create? Or rather, how else can we reduce our volume of cases? How do we reduce the caseloads? If you're thinking there's a simple answer, there's not. That's why it's still a problem. All right, the other solution that is currently in place, again, but there's always more that can be done, is speed up court processing. And so, how is that done? Well, we've enacted at different times speedy trial laws, which it stipulates to the court and to the prosecution how many days from that initial appearance in court when the charges are formally read to the date of appearing in court to the trial itself to like several different stages. They have a limited amount of time. If on the prosecution side they do not file those things within the proper timeline, the case is dropped. So like this is a way to make sure, is it an unnecessary case or is this something that's really should be heard? Obviously, if it's a priority, you're going to make sure that everything is done on time. So there's logic behind it, but obviously, well, if we just speed up the whole process by forcing limits on time, how effective can an investigation be? Gathering of evidence, how effective can that be? So there are some good and bad with both sides. I'm just playing devil's advocate here, so I just want to emphasize, like, you want to dig a little. So I pose to you, how do we solve the problem of a high volume of criminal cases that are slowing down the system? That may be the discussion board question. Who knows? All right. And then our author changes gears just a little bit and talks about the role of judges, and particularly looks at trial court judges and appeals court judges because there is a distinction. So a trial court judge tends to be active and present throughout most of the actual process that we've looked at. So they're involved with issuing warrants, search and warrants. Wow, sorry. Search and seizure warrants, things like that. So they're involved with that. They're involved with bail. They're involved with pretrial motions. They hear pleas. They referee the trials, and they pass sentences. Like, they are in most of the actual process. And one of the struggles that they have is they have to balance between the rights of the accused, so making sure that they have all their constitutional rights, that things are fair, but they also have to operate with the best interest of the public. So if the accused is accused for extreme violence, is it best to let them continue going free until trial, or do you put them in prison? Is imprisonment unlawful because they didn't actually do it? Like, there's a lot of gray area, and so that's the big thing that our trial court judges have to deal with. Appeal courts, or the appellate court judges, these are judges that act more as a legal scholar. Again, remember at the federal level, the appellate court has 3 judges. The goal is that you are, not you necessarily, but if you do decide to be an appellate judge, your job is to research, clarify, and write opinions on legal issues. you're looking at the Constitution and saying, well, what does the Constitution actually say? That's where we get the idea of constitutional lawyers, people that look at, read, know the history, and pretty much try to interpret what the Constitution says. Again, sorry for the coughing. All right. And then let's talk about federal judges. So federal judges are the top decision makers, and this is where we have a little bit of an issue. Remember how we've said, the criminal justice system is kind of inherently political because you're either put in place by someone or you're elected by people, so you tend to have some kind of political party or agenda or way of viewing things. So it is inherently political. Well, at the federal level, typically speaking, and I mean like historically typically, there are exceptions, but federal judges tend to come from long lineages of civil workers. So it might be a long history of judges, maybe a long history of lawyers, maybe a long history of government officials. Like there tends to be some kind of family business aspect to it. And they also tend to have degrees from the top law schools, so they had the best educational opportunity. So the danger in this is that it can seem that only the elite become federal judges. And so, yes, that definitely creates some minor disappointment for some people and disillusionment in our system itself. Again, typically and historically, it has been these individuals, the elites of society. Obviously, throughout history, there have been some individuals who aren't, but the majority tends to be these people who are more well off. So I encourage you, become a federal judge, become a chief justice of the Supreme Court. Do something big, especially if you don't come from a family like that. Say that you got your start at a community college in your hometown. Be that person. I want to be proud of you one day. Be like, that's my Supreme Court justice. Sorry, that's my personal thoughts. Okay. So thinking back from federal judges, we have state judges. And so something that our book talks about is they tend to be chosen based on political party of the state. Again, remember, we are a inherently political system. Either people are appointed to those positions as judges or they're elected. And so I did a little research to make sure that I gave the accurate information. In Pennsylvania, where we live, Pennsylvania is an election state. Most of our judges are appointed via an election. Those that are appointed tend to be because of an emergency vacancy, like a death or something like that, during a term. But typically, Pennsylvania is an election location, an election state for our judges. That's just, again, if you plan on working in PA system, it's important to know. All right. And so our author switches gears from talking about judges to talking about judicial decision making. And this and the actual structure of how the court works and operates is going to be the bulk of everything. So this first part was mostly review. So now we're getting into new stuff. And so in judicial decision making, there's this concept, this doctrine of stare decisis. I'm not going to write it, but it's the idea that you adhere to a previously set precedent in decision making. We've talked about this before. This is where the concept of precedent with cases comes from, is this judicial doctrine. So that's important to note. Decisions made previously, precedents that were set, are what help shape decisions made now. And so, to quote Spider-Man, and not Spider-Man Homecoming or any of the newer ones, and not to quote, well, kind of quoting, it's been in all of them, but with great power comes great responsibility. Remember that judges, their job is to interpret the law, which that's a lot of power. They're not supreme power. Even Supreme Court is not all supreme, but they do make these decisions. They have a lot of power. And anyone that likes superhero movies or knows Spider-Man knows with great power comes great responsibility. To seem fair and impartial, you do your best to make sure that everything is equal. But to be honest, and this is something that at least needs to be mentioned, there is a problem with misconduct. When people have that much power, sometimes people make bad decisions. It can be acting in unethical ways, or it can simply be doing something illegally. When a judge does one of these things, whether acting unethically or acts in an illegal way, what they are doing is they are undermining the system that they serve. They are not setting a good example, and that's not what you want from the justice system. You want it to be fair, not one-sided. So, at the federal level, this is just an important thing to note. At the federal level, judges can be removed only by impeachment and only by the Senate. Any Star Wars fan out there goes, I am the Senate. That's why our system is designed the way it is, to be a balance. But yes, and this does kind of come from a historical point. This is judicial independence, this whole idea that at the federal level, judges are removed by impeachment by the Senate, by one of the equal body powers, but at the same time, they're that top level of decision, and that's this judicial independence that our founding fathers, so 1776, made this decision. Well, not 1776 exactly, but the decision was at this time, at the founding of our country, this was the idea that there needed to be separate power so that judges, which already existed, they were the judicial people. There weren't really a bunch of lawyers, but they were judges. That judges needed to be fair and neutral over all cases so that they can keep things as neutral and fair as possible. So that meant that they had to be separate from the rest. And their other secondary job, if you remember from like middle school history, was that their job is to keep the legislative and executive branches of government in balance. Unfortunately, the issue is that they're all closely tied together. So while in theory, yes, Supreme Court, the judicial system itself and the judicial branch of government is separate from the other two, obviously, there are appointments by the executive branch, so people tend to have some kind of connection to the other branch, and so they feel like they have to follow in suit for that person. In the legislative branch, they get to make the decisions on finances. They decide how much money goes to what courts. And so, like, that's kind of an issue. So it is meant to balance, but at the same time, there are some disproportionate issues. And so obviously, juvenile courts, we're not going to talk too much about the juvenile courts. I want to really focus on the Supreme Court and some of the juvenile court cases, just because I think it's really important to emphasize this. So we've already talked, judicial court early on was many adults. And as we've kind of talked about before, parens patriae, the court acting as parent, or rather the parent acting as a decision maker. All these things we've talked about before, but there are some court cases that are really kind of important that I at least want to put forward. They could show up on a final. They wouldn't necessarily show up on a weekly exam. So Kent versus the United States in 1966, this was the court case that decided that juveniles are afforded due process rights the same as adults. So they've already been in their own system, but up until that point, they didn't have the same rights as an adult does in a court proceeding. So this was, okay, they actually deserve the same rights. And so in Galt, 1967, it just held that if you're accused of a crime, even as a juvenile, it just reemphasizes you must be afforded many of the same process rights as adults. This one is important because we're going to talk about this concept. Breed versus Jones in 1975. A child delinquent in juvenile court. So they have that, and then trying the child in adult court amounts to double jeopardy, which you're not allowed to do. That is something that is in our system that you cannot be in double jeopardy. And for anyone unfamiliar with that, double jeopardy is this basic concept that an individual cannot be tried twice for the same exact crime. Obviously, an appeals or having a different court overhearing is, or a different jury hearing is different than a second sentencing. But this means that obviously, you had a court for a child in juvenile court. And then after that, regardless of the outcome, you tried them as an adult in adult court. That's double jeopardy. It's the same crime in two different places. You can't do that. And so double jeopardy comes up later, and we'll talk about it a little bit more then, but I wanted to emphasize this. So some of the other big ones, Shaw versus Martin, 1984, this was that preventative detention for a juvenile doesn't necessarily violate due process. If you remember, individuals can potentially be released to home. This is the whole idea that if a child is potentially a flight risk or things like that, they can hold them in juvenile detention until their actual case. It does not violate their freedom to be out, that kind of thing. Doe versus Renfrow, 81, is the classic of school children with narcotics. Being subject to a search by a drug dog is not actually a rights violation. So this one, if you've been in elementary, middle, or high school since 1985 when this happened, you're familiar with this. New Jersey versus TLO. It's the evidentiary standard for searches of students by school officials at reasonable suspicion. This is where locker checks and everything, either by a retention officer or by a school official. This is where those standards for what is classified as reasonable suspicion to search a student's private property as well as school property. So this is a big one. And then I never pronounce this correctly. V. Strauss, 1993. This is curfew laws are constitutional because they're designed to protect the community at large, not just the juvenile. This is one of those, much like holding them in juvenile detention because of a potential flight risk. They would be a harm to the community if they were out after a certain point. So curfew laws are not a violation of their right to freedom because, it's designed to protect the community at large. So, like I said, those are the key cases that our author brings forward about the juvenile system. Obviously, when we talk about juvenile justice in the separate class, as well as a little bit in the last week, we'll touch on some of that a little bit more. All right. So, as you can tell, when I go over the notes, I go over section by section of the chapter, if you haven't picked up on that already. So, you can follow along with the book as I'm going over these notes. So the next thing that our textbook talks about is the prosecution and defense. And so this is where we're getting into the nitty-gritty of how the court system works. And if you remember from every week I talk about it, I get excited about this. This is part of what I wanted to do when I was first interested in criminal justice. So if I seem a little more excited to talk about this, it's because this is where my passion was. Not to say the other things aren't important. I just get excited. Okay, so one thing that our author wants to emphasize, and we need to emphasize it here yet again, our system is adversarial in nature. Two equal sides fighting to win. And that's where we have the prosecution and the defense. Those are the two sides in our court case, specifically our criminal court case, because we have talked about, at least at the civil level, we have the plaintiff. So that's a little bit different, and we won't talk about it in this chapter, but we have talked about it before. We're going to look at criminal cases right now. So, in a criminal case, we have... I should probably write this. Hold on. Give me uno momento, por favor. We have SEC Q-T-I-O-N. So we have the prosecution, and we have the defense. Oh, sorry about that. Every once in a while, I think I'm doing something good, and then it turns out to be not so good. All right, so we're going to talk about the prosecution first. And so we have talked a little bit about it before, but this is the body that represents the government. So whether that's the local government, the state government, the federal government, this is the people that are trying to prove that this individual committed a crime. And so if you remember, and we talked about it quite a long time ago, the burden of proof is on the prosecution. Their job is to prove without a shadow of a doubt, beyond reasonable doubt, that the defendant is guilty of the crime. And so they present the government's case, and their purpose is to demonstrate their guilt, the guilt of the defendant, to the finder of fact, also known as the jury. Hint, hint, that was something from the test that a lot of people got wrong. The jury is also known as the finder of fact. The Le Petit jury is a separate thing that we will talk about briefly here in a few minutes. Anyway, in federal court, our prosecutors are known as the U.S. attorneys. So all 94 federal districts have an attorney, and they are appointed by the president and function as administrators. So they don't always necessarily run a case. They might be part of a case, or rather they don't. By run, I mean they're not the primary speaker in a case. Obviously, there are assistant U.S. attorneys, and they're the ones that tend to conduct more of the actual prosecutions. And so you might have heard the Attorney General. That's a title in the United States government. They are also the head of the Department of Justice, but their other main goal is that they supervise the U.S. attorneys, both them and the assistant U.S. attorneys. So they're in the top levels of that big pyramid of hierarchy. And so we've talked about it a little bit before, but remember, federal crime, the focus for the federal courts tends to be on violations of federal law, so things that are about the whole nation rather than an individual location, public corruption, large-scale drug trafficking, and white-collar crimes. Obviously, there's things like, human trafficking and other stuff that would qualify under this, but these tend to be the big ones. At least the big ones that go to court. So then at the state/local level, these are often known as district attorneys. These individuals also have discretion, much like our higher ups do. In some jurisdictions, just want to emphasize there are city attorneys for minor offense. So technically you could have a city attorney to look over, just misdemeanor crimes. And by misdemeanor, I mean even lower misdemeanors like a traffic violation, or in Erie City proper, there's the, decriminalization of marijuana where you can get just a fine, that kind of thing. So those would be city prosecutors or city attorneys if needed, but we don't really need to talk much about them. But district attorneys, in having discretion, they too get to pick what cases to see and pursue going to trial and which ones aren't. Remember, not every case goes to trial, and not every case that goes to trial results in a trial. Sometimes they end in a plea bargain, more often than not. We've talked about some of these things before, so it's just important to re-emphasize and come back in on things we've talked about before. And so there is another thing that can happen within the prosecutions, the different types of prosecutors. There's a thing called an independent counsel. And an independent counsel is usually used in high-level government official cases, where the idea is that you need a neutral third party to avoid corruption and bias, because you don't want any kind of influence over an investigation. So technically speaking, there is actually a recent case of an independent counsel in a sense. If you've been following the former President Donald Trump Mar-a-Lago issue, they did request a a special master to oversee. They fit very much the same way into that independent counsel, where they are an individual not directly involved with the case. It is supposed to be a neutral third party that oversees all the things that was gathered and determine if there is a case. That's what the special master is in this current case going on in the United States. Obviously, if things happen, I might have to post more information about this, but I at least want to emphasize that this is a good way to kind of understand how it fits into there. Okay, so remember when I said prosecution also has discretion, or rather I said specifically the district attorneys have discretion. So there are 3 areas of discretion that they have, and I already mentioned it. That's really, to file charges or dismiss charges. So those are the 2 main ones, but there are also the ones that offer plea bargains. So all 3 of those things that we've talked about before, these are all the 3 ways that the prosecution has this ability to use discretion and determine if a case has enough evidence to file a charge or dismiss a charge or to offer a plea bargain, that kind of thing. And so once we get done with that, we then look at the defense, and we'll talk about the defense here in a minute. But our textbook does talk a little bit about under the prosecution section. It talks about charging and dropping charges and plea bargaining to really kind of emphasize how these 3 operate. And I'm hoping that a good number of you already understand a lot of this, but I am going to go over some of it a little bit just to make sure everyone has an equal knowledge base. So in filing a charge, while police initially inform a criminal defendant, the individual who's being charged, they may give them the initial charges against them. It's up to the prosecutor's team to decide what the exact formal charges are going to be. So the officer may say you're being charged with illegal possession and go through like 8 other things. The prosecution gets to decide what exactly they're going to be pursuing. And that, again, depends on evidence that's already available. So the other thing that they do is kind of gave it away, but prosecutors weigh a lot of different factors when deciding whether or not to charge. So obviously available evidence, current caseload, availability, flight risk, repeat offender or first-time offender, severity of the offense, you name it, it's something that they probably look at. Because realistically, every case is a little bit different. Even if it's the same exact case, something is a little different every time. So you end up getting to make that decision. In regards to dropping a charge or dismissing a charge, once a charge is filed by a prosecutor, there still is discretion on how to proceed. Obviously, they can go to trial, but they could also decide to offer a plea bargain, which is part of this dropping of charges. Obviously, we'll talk about plea bargaining here in a minute as well. But so that's part of it. But there's also this null prosequi, where the idea is that the case is dropped. And our text offers 4 particular ways in which a case could be dropped due to this. And I do want to just talk about it. A case can be dropped because it's trivial in nature. So it's just a really minor thing that shouldn't take up anyone's time or taxpayer money. There's inadmissible evidence. So obviously, if most of the evidence or some of the evidence that really is needed is not allowed to be used in the case, they might drop the charges. Insufficient evidence is a very big one. Obviously, if you don't have enough evidence that you think you can actually convict, you might not pursue the case. And then the other one, which I think is important to mention, is false accusations. So this happens. We talked about it a little bit in our week 4 when we talked about the Innocence Project a little bit. people can be falsely accused and falsely imprisoned. So this idea that you can drop charges because of a false accusation, this ideally prevents needing to release someone from prison after they've already, been committed. That's kind of the goal. And then plea bargaining, like I say, this is a way to conserve resources and speed up the system. Technically speaking, a plea bargain is a win-win scenario. The prosecution gets the guilty plea, and the defense gets a lesser sentence or punishment from said plea. So it is a win-win on that basic level. Yeah, just remember Hollywood, so television, movies, games, things like that, is fiction. A lot of the way things operate in the criminal justice system is not exactly as you see in movies and television. All right, so that's prosecution. Let's talk about the defense. Excuse me. So the defense, their goal is to champion for the defendant, for the individual being charged with a crime, every step of the way. So pre-trial work, they are supposed to be there to represent them at bail, any suppression hearings and other pretrial matters, represent them in court, at sentence hearings, and if the individual wants to appeal an unfavorable result, the defense should be in support of that. They should be part of that. So when we talk about defenses that a defendant can use, there are three ways of doing it. And I should emphasize what I mean by three ways of defense. I mean the three ways that they can go about having a defender. So one is hire a private attorney. This is the one that people tend to hear a lot about. The other one that people tend to hear, well, actually, let's be honest, everyone's heard of all three of them. It's hiring a private lawyer, private attorney, someone to represent you. There's using the legal services provided by the government for the quote-unquote poor. The particular term is indigent, and we'll talk about that here in just a little bit. But this is where, the public defenders come in, and there are a lot of stigmas with that, and we'll talk about it. And then the third option is, of course, represent yourself. And, yeah, representing yourself, not a good idea. Just period. Just people that tend to represent themselves tend to have a higher rate of being imprisoned. So don't represent yourself. All right. And so in that chapter in particular, we do actually have another couple cases that are brought up. And that is actually, I believe, right here. No, where is it? I don't remember where it is. But there are two cases that are mentioned, and that is, I'm going to write them down because I can't find them right now in the text. And that is 1963 with Gideon versus Wainwright, and 1972's Argersinger versus Hamlin. Okay. So, these two cases, these are big in the defense case. I should probably put them under defense. There we go. So 1973, Gideon versus Wainwright. This is where the idea that the indigent defendant had a right to be represented by counsel. So before 1963, if you couldn't afford a lawyer, you didn't get one. You had to represent yourself. And this was where we're like, well, you know what? That actually is not fair. The whole point of our system is to be fair and impartial. And if our person can't afford a lawyer, that's not equal grounds. So that's where if you cannot afford a lawyer, you will have a lawyer given to you, or you will be appointed a lawyer and that kind of thing, so that you will still have representation. That comes from 1963. And then 1972, Argersinger versus Hamlin. This was also the right to court-appointed counsel when there is danger of a prison sentence. This was to kind of build off of Gideon versus Wainwright. where obviously if there is the potential of a prison sentence to the case, the individual has the right to have a court appointed counsel, so that, if they can't afford one or they don't think they qualify for a public defender, the court will assign. So that's where that comes from. So these two cases are very important for the concept of being equally represented and having a public defender. And so today, minor offenses with only fines, like traffic violations, aren't constitutional for a state-funded counsel. You don't get to have excuse me. Wow, I'm really struggling with this. You don't get a public defender for a traffic violation. If you want a lawyer, you got to pay for them. All right. And so I did mention, I would say in a couple minutes, indigent. So indigent itself has two kind of definitions. It's poor/needy. Needy is the better word. So realistically speaking, it's more for the needy. And this is where I wanted to look up a little bit more, because our author even says every state does have its own rules for what qualifies for the minimum requirement for a public defender. So in PA, it is a county decision. So since we are in Erie County, I looked at Erie County's public defender, and it follows the federal poverty guidelines. So you have to be, your income has to be under a certain threshold to qualify for a public defender, and that's annual gross income. So, that kind of stuff. But it's also based off of property interest and the nature of charges. So realistically speaking, if the charges are pretty bad, but you might be able to afford a lawyer, but it would require massive changes to, family, housing, eating, things like that. There's a possible consideration, even if you are above the federal poverty line. So pretty much it's a case-by-case basis for Erie County, but it's just important to note that, as our author said, it varies by jurisdiction, it varies by state, and here in PA, they redirect you to your individual county. So if you are a resident not of Erie County itself, which I wonder why you're coming to Erie County Community College, but look up your particular county and see, what are the requirements, because they can vary. I would argue that most of them probably follow the federal poverty line as a basis, but I'd be interested to know, more about that. Again, remember, I like to make sure that we talk about Erie County. All right. And so our textbook even talks about it. Public defenders and court-designated defense. This is free legal defense. Well, what's the issue with a free legal defense? Shouldn't it be a fair and equal thing? Yeah, I don't think any of us would argue that, but there are some critics to the system that point out, it's taxpayer money that's funding to exonerate or to allow a criminal, quote unquote, to walk free. Obviously, that's not completely accurate. That's a whole kettle of fish, and we're not going to dive into that, but that is a problematic decision. Yeah, how is a public defender paid? They are paid through, local and city taxes. That's part of where that money goes. Well, not that money. There's a lot of other things, but the public could view it as we are paying for a criminal to go free. So it tends to be a politically messy issue. The other thing is, this is where the traditional arguments about it come in, and I want to just talk a little bit about it. Overloaded public defenders don't act in the best interest of their client. So there is this kind of... It's not accurate. That's what I do want to say, is it's not totally accurate that a public defender is an inherently worse lawyer. They're not. They go to law school just like any other lawyer. They pass the bar exam like any other lawyer. The only difference is that they are put on cases for individuals who can't afford counsel, and they are compensated differently, less so than their private practice counterparts. Other than that, there's really not a whole lot of difference there. However, just because that's true doesn't mean that, it's not all there. When considering a public defender, something to note is that there are some statistics that point that, individuals who are represented by a public court appointed attorney tend to accept more plea bargains and are sentenced more to jail than private lawyers. That's not to say that they don't act in the best interest or they're not good lawyers. It's just the data. It's a question of, is it causation or correlation? If you're not familiar with those, take English 101 or English 90. You learn about those there. But it's kind of important to note that the stigma behind a public defender is not necessarily fair. And so I want to try to break down that stigma. Our author tries to talk about it too. So if you do decide to go into law school and become a lawyer, if you start out or want to be a public defender, don't let anyone talk you down. Don't let anyone talk down to you like you're less. That's a really cool thing. Anyway, so if you go with the private, obviously there's a different thing. It's called retained counsel, and the idea is that a private attorney usually has years of experience, and they can kind of charge pretty much whatever they want, but the fees are related to the complexity of the case and the amount of work that's required for it. That also includes appearances in court, so it ranges. Obviously, self-representation is you are voluntarily waiving your right to a counsel. That's why we say don't do it. In general, the defendant does have rights, and this is the concept that we like to throw out all the time, that, innocent until proven guilty, but boy, do we have issues with that one when we really try to talk about it. But everyone is treated fairly in the process is the whole concept behind this, and we'll talk about where that comes from. All right, let's talk about the pretrial process a little bit, and then we'll get into the actual, I guess we talk a little bit about the history, and then we're going to get into how the trial actually works. And so in the pre-trial process, the individual has a right to an attorney. And we've talked about this a little bit, but this is the belief that a public defender, appointed lawyer, didn't do as well as private attorney, all this stuff that I just talked about. I found my note. Bureau of Justice Statistics shows that there's very little distance on obtaining a guilty verdict. However, appointed counsel had higher guilty pleas. But yes, the right to an attorney, like I said, we don't really need to talk more about it because we've already addressed it. But, before the Criminal Justice Act, there was no authority to compensate appointed counsel. So it was always expected to be a pro bono thing. So they do it without pay. But obviously, much like our cases here, we have, 1964, the Criminal Justice Act was actually enacted that it compensated appointed counsel, obviously significantly lower than private counsel, but they were given something. And then in 1970, it was amended to authorize districts to establish federal defender organizations as counterparts to federal prosecutors in the U.S. Attorney's Office and institute resources for providing counsel. Now, I went over that fast, but the big piece that I want to get to is this. As of the time of when the textbook was last updated, 81 authorized federal defender organizations exist in the United States and serve 91 of the 94 federal judicial districts. So this means that there are 81 public defender operations across 91 of our 94 jurisdictions. That's big. That means that this is not, like I said, don't look down because it's a public defense. It's an important thing. All right. Now, still in the pretrial process, we talked about the decision to charge, at least from the theoretical level. So if the prosecutor decides to move forward, a charging document is actually filed. There's two types of charging documents: an information charging document and an indictment. Obviously, an information document originates from the prosecutor, whereas an indictment originates from a grand jury. And we have talked about grand jury before. Do I have it written down? Yes, I do have it. A grand jury, their whole point, as we've mentioned way before, but again, need to reiterate, grand jury determines and makes determinations on moving to trial by a judge, or in the sense of the term grand jury, is a panel of citizens. They typically, the panel of citizens do this, become the grand jury. Their whole point is to hold a hearing in private and listen to the stuff and determine if it should go to court. We'll talk about the issue with that here in just a moment. So typically, the grand jury is larger than the trial jury, the petite jury. So obviously, yes, the trial jury is also known as the petite jury. But again, on the test, what we were looking for was they are the finder of fact, not the petite jury. Just want to emphasize that. Okay, so when grand jury hearings are held and they're held in private, part of the issue with that is that not only are they held in private, but hearsay is allowed as evidence in those actual places. And so there's not even a defense attorney. It's literally just prosecution goes, do we got enough? Sure, let's go. Boom, done. Doesn't matter if it's hearsay evidence or not. They make that decision. And so some civil rights groups, it was started with the intention to protect the public. It was in mind with civil rights that, a council of citizens would look at a case and be like, yes, this case should go to court, or no, this case shouldn't go to court. The idea that just a judge could decide was not fair. Nowadays, the more modern thing is you're allowed hearsay evidence, and the defense is not allowed any kind of argument at this stage. So it kind of takes away the fairness and equality of the court system. It's controversial. It's an up in the air thing, and I don't know that I see it changing anytime soon, but it's important to note that. Okay, now I'm going to go back just a tiny little bit, just simply because we talked about the grand jury and I wanted to talk about it where it was. So I jumped a little bit in the text. So after decision has been made to charge or not, the individuals, the prosecution reviews the charges to see if probable cause is actually the standard of proof there, if they can prove that. And then they determine if that move is actually justified. And that's when we get that first appearance. First appearance is not when the police officer shows up. First appearance is charges are officially being read. So defendants are informed of the nature of the charges. The constitutional rights are explained to the individual. If they are indigent, counsel will be appointed, and the judge determines if bail will be granted. So, if you weren't totally positive on the way the trial processes or the criminal justice system processes as it was on the exam, this is important to pay attention. Okay. So, after first appearance is when bail, as I said, judge determines if bail will be granted. And we've talked about bail a little bit before. Just a reminder, it's that monetary value that says, I will show up in court on this day. The issue in general is that commercial bonding, where we always do bonds, discriminates against the poor because they can't afford that. They can't afford a lawyer, so they have to get a public defender. They can't afford to post bail, so they have to stay in jail. Like, it seems like it is one-sided. It is against the poor. Just an important note. Just want to clarify. Just wanted to give equal examples. All right. The other thing that does come up from this, and we've talked about it a little bit before, sometimes bail is not given, and that's in a preventative detention manner. And so this means that we are detaining the individual so as to prevent any further crime. Well, preventative detention also seems a little bit counterintuitive to innocent until proven guilty. But regardless of that, I do want to point out that the innocent until proven guilty comes from Coffin versus the United States, 1895. So if anyone says, well, it's a constitutional right, it's not. It's not in the Constitution. It's not from the Bill of Rights. It's not from an amendment. It's from a Supreme Court decision that an individual cannot be, unlawfully held, or any number of these unfair things that happen to an individual until they're proven guilty. So I just thought it was worth mentioning here. And then obviously the Bail Reform Act from 1984 gave federal judges the authority to hold suspects without bail when deemed a threat to public society. Or public safety, not public society. That's a redundancy. So preventative detention, while it seems to be the innocent until proven guilty, if a judge feels that the individual, the suspect, is a potential threat, they can supersede that and do preventative detention and hold them until trial happens. So anyway, so after all this, we get arraignment. And the arraignment stage, ARRAIGNMENT, arraignment is the next step where a judge informs the defendant of the charges officially, and they enter a plea. And so there are three types of plea. There are the guilty plea, the not guilty plea, and the nolo contender, which is no contest. And so it's important to note, guilty, not guilty, no contest is the most common phrasing for this nowadays. So obviously, if you plead guilty, you're saying that, yes, you committed these and may go to trial, may be a bench trial where, the judge just makes the decision on punishment, that kind of thing. So guilty, you admitted guilt, you said I did it. And if it does go to trial, they can use that you pled guilty as evidence. Not guilty, same kind of concept. You're saying I didn't do it, and then it usually goes to trial where the prosecution has to determine and prove without a shadow of a doubt that you did in fact commit the crime. No contest will go to court. That's what's going to happen. It's going to go to court, but the difference is, like guilty, it's going to go in, but there's no evidence. There's no admission of guilt from that stage. So if you plead no contest, that means you're not saying you committed the crime, but you're also not saying you didn't commit the crime. So there's no way that they can use that decision, that plea that you gave, as evidence in the trial. So by simply choosing no contest, you're not saying guilty or not guilty. Obviously, anyone who's like, well, why wouldn't you just say not guilty? This is one of those great questions that you have to ask the individual who went through it, not me, who can theorize and pontificate, which is a fancy way of saying think and speculate. Okay. And so after this arraignment moment, there's this availability for pre-trial motions. And this is usually one of two things. It's either the motion of discovery or a motion to suppress. And so I'll easily talk about motion to suppress first. Simply, this is put forward by the defense to disallow any illegally obtained evidence being admitted in court. This is where, the constitutional right of they got this particular thing illegally. It should not be admitted in court to prove that my individual is guilty. That's a motion to suppress. Motion of discovery. This is a little bit morally gray. This is the concept that all evidence that the prosecution has must be made available to the defendant. And so most people are like, but that should be a standard anyway. Yeah. So technically speaking, the prosecutor is legally and ethically obligated to turn over any exculpatory evidence. And if you're wondering what exculpatory is, exculpatory evidence is just evidence that of the individual's innocence. And so, yeah, technically speaking, the prosecution is supposed to give the defense any evidence that they obtain that proves innocence. It gets into a debate, and it should never be an issue, but when we talk about corruption in general, this is a location for potential corruption, for potential occupational illegal action, occupational crime. Look at that. We're using terms. All right. If you have been listening straight through, pause the video, take a 5-minute break, because now we're going to get into the actual trial, and it's going to be mind-numbing. So please take a break real quick. I'm not going to take a break because I just got to get through all of this. But I encourage you to take a short break to rest your mind between this first part and the next part. All right, and so hopefully you took a break. If not, whatever you believe in be with you. Whew. We're going to talk about trial. Specifically, we're going to talk about the trial structure and how it works. And so, excuse me, a defendant has the ability to waive a trial by jury and just do a bench trial. We kind of have talked about it a little bit before my suggested break for all of you. That's where, the bench trial is the judge is the jury. That decision could be made technically fairly quickly. Regardless, defendant can waive those rights to having a jury of their peers weigh in on their crime. And so we do need to talk a little bit about jury numbers and how they're selected. And this is another one of those, they vary by jurisdictions. So this is one of those things I can't totally speak about PA, or Erie in particular. But most jurisdictions follow the same kind of breakdown. These are things that you find out when you go in for jury duty. Both times I've been summoned for jury duty, it's been canceled. So I haven't gone through the system myself personally. So it always starts with questioning potential jurors. And the whole point for this is you're trying to eliminate bias. And if you've taken English 101 with me or someone else, you've probably heard the term bias before. Hopefully you've heard it without those classes. But the whole point is a juror on a trial should be unbiased. They shouldn't swing one way or the other about an opinion relating to that case. They should be as neutral as possible because the fate of an individual is in their hands. If a potential bias is noticed, a challenge for cause is the official term for removing a potential juror based on the idea that they have a bias. Excuse me. Man, my throat's really hurting me right now. Okay, so the other things that they can do is they can eliminate some jurors, I wouldn't say prematurely, but early. And this does have its own separate term. I want to make sure that I'm in the right area. I might actually already be on the next. Yeah, I am already on the next chapter. Sorry, I kind of flew through chapter 5.3. All right. So there is the peremptory challenge. And this is essentially giving each side a certain number of overrulings and disqualifications for potential jurors, where you don't need a reason to deny them. You see this in some television shows that are court dramas, but typically, this is just overruling certain jurors or disqualifying them without a reason giving. All right. Then once that happens, going forward to trial is serious business. So usually this is reserved for compelling cases. Typically, a prosecution doesn't proceed unless they feel like they have actual enough evidence to prove this. So statistics show most criminal defendants who take their case to court or to trial are found guilty. Plain and simple. That is just data for you. If it goes to trial, it tends to be a guilty. Okay. And so some of these ideas I think you probably will be familiar with. Like in the process of the trial, it starts with opening statements. If you've watched any crime drama or law movie, you're familiar with opening statements. This is just, both sides get a chance to give a roadmap to the jury, excuse me, what they intend to prove. It's important that this is meant to be non-argumentative. It is supposed to be just about the facts and evidence. And so if you think Hollywood, wait, they're always trying to argue. Well, yeah, and it's Hollywood, so it's over the top. But they're still argumentative in nature. And this is where I say take English 101 or 102 to learn more on how to argue without arguing, because that's pretty much what you're doing. So if you have taken one of our English 101 or 102 classes, think about, things like TAPIC and KELP and how you can make something an argument without sounding like an argument. It's just a little side note for some of you. All right. So both sides, regardless of what they put forward as facts, must have evidence. And that's important. You can't say something happened without evidence. This is true for writing. This is true for college. This is true for everything. You need something to prove your facts. You can't just say it and it means it's true. You got to prove it. And so this is where we get some terms like testimony and testimonial evidence. This is any statement by anyone who has direct first-hand knowledge of an event, specifically the event that's related to that case. And so this has to be someone who witnessed it, heard it, saw it, felt it, engaged in it, whatever it may be. Testimony has to be from someone who has firsthand knowledge of the event. Direct evidence is any kind of evidence that proves directly the fact that is up for question. So this is biographical information. This is fingerprints. This is location. This is stuff that you just look and see. Yep, that there you can't prove that it's not. And then there's circumstantial evidence. And this one Hollywood likes to dive into. And that's this, you're inferring, you're implying that a fact exists with this. And so this one is kind of a gray area. This is where interpretation comes in. And so it's important to remember, you want testimonial and direct evidence most, but circumstantial evidence does have its place. But again, it's an interpretive thing. And then there's one other type of testimony to talk about, and that's hearsay. Again, if you've watched any kind of crime things, you're familiar with the term. Specifically, hearsay is testimony from someone without any direct knowledge of the facts, and they're in fact hearing it secondhand or maybe even third hand. So when you see in court cases both factual that are shown to the public as well as in dramas, when someone says objection hearsay, the concept is that they are talking about an event that they were not actively there for. So they didn't see an individual throw something. They didn't hear the shattering of glass. They weren't actually there. They heard from their friend or their partner told them, or pretty much, oh, I saw a picture of this. Well, were you there for it? No, then it's hearsay. I just think it's important when these terms come up that are used so prominently in Hollywood versions that we talk about what they mean. I want to take away the illusion and show the factual side of what the criminal justice system looks like. Sorry for getting a little serious there. I just want to bring that up. All right. So after we have our opening statements, yes, this was in the section for opening statements, but it's not opening statements. This is part of what comes next, and that is the prosecution's case. And this is where the state's evidence is pulled forward. And this is where we get testimonial, direct evidence, circumstantial evidence, that kind of stuff. This is where the prosecution calls witnesses, conduct direct examinations, and important to note, the defense can cross-examine the witness. And this comes from the confrontation clause. And that's the right to face and question those who give evidence against the accused. So it's important to note that the prosecution makes its case in a criminal trial, and then it's the defense's case. Because remember, again, the prosecution is designated to have the burden of proof. They have to prove that they are correct. They have to prove without a shadow of a doubt that the individual did commit said crime. So they got to prove it. The defense goes second and gets a chance to go, yeah, let's look at all that evidence and say why it's not right. So important thing to note, in a criminal case, the defense does not have to present any evidence since the burden of truth is on the prosecution. Their job is to just prove that the prosecution did not prove beyond a reasonable doubt that the defendant is guilty. That's all their job is. So they only have to look at all the evidence presented. Now, they can present evidence, but it's not required. And so some strategies for the defense to take would be, the defendant actually takes the stand and testifies. Of course, this also means that they can be cross-examined by the prosecution. So take it as you will. This is where alibis are provided to, disprove some of the particular facts of the case. They can provide different accounts of events from the facts presented from the prosecution. And they can also attack the credibility and competence of witnesses that the prosecution called. These are just all the common strategies that are used. And so after the prosecution makes their case and the defense makes their case, then we get to the closing arguments. And the closing arguments are really just a chance to summarize the evidence presented and clarify any opposing theories. So it's important to note this is limited only to evidence presented. You can't introduce new evidence or refer to something that was not presented in the case. So if you forgot something, I'm sorry. If it's closing arguments, you don't get to bring it back in. All right. And much in the same way as opening statements, as well as defending, or rather going through and putting your case forward, closing arguments also goes prosecution first and then defense. However, in many jurisdictions, prosecution has a chance for a rebuttal before the jury after the defense makes any claims. So take that as you will. And then the jury is given instructions on how to proceed, and this is where the system is pretty much the same throughout. The jury has to enter deliberations and assign a foreperson. The term was foreman in the old days because, well, women did not have the right, but now that, we are more inclusive, it is a foreperson. And the whole point of the jury in deliberations is to discuss the case and determine their decision. So they look at just what was presented in the case, not what's going on social media, not what the news is saying, not what was presented in the case. And so you have to talk about that kind of stuff. And if a decision is not met by the end of the first day of deliberations, this is when a decision can be sequestered, or the jury can be sequestered, rather. And this is where the jury is moved to a secure location. Sometimes this is a hotel room. Sometimes they're allowed to return home, but they are compelled to avoid contact with people in media that could provide non-court provided information or evidence that could impact the trial. Because remember, only evidence presented at the trial can be used for or against an individual. So you can't talk about it outside. You can't do research outside. So once they do figure out their decision on the process, most states require that the final verdict in a criminal trial has to be unanimous. This means that everyone agrees. Or rather, yeah, a unanimous just means everyone agrees, not majority, everyone. If you are not able to reach a unanimous decision, the term is the jury then becomes a hung jury. If a jury is found to be hung, the judge is required to dismiss the case. If it is done in this way, the prosecution can retry the case in front of a new jury. That way, they can hopefully a different set of peers can see the evidence and go, oh, yeah, this is definitely this, and they can be unanimous in their decision. If found not guilty, though, the prosecution cannot retry the person for the same charges because that would be double jeopardy. They were already in court for that. They went through trial and they were found not guilty. That means that the prosecution can't retry that individual for the same crime. That's double jeopardy. All right. And so there's another term that comes, and it has to do with sentencing, and in particular, it has to do with the death penalty, and it's bifurcated. I just want to make sure that you get the word. I don't know why I struggled to write that T. Please forgive me. So in a case of like death penalty, the decision is actually a bifurcated decision. The first part, bifurcated just means that it's split into two parts. So the first part is where the jury renders their verdict on guilt. So they're guilty or not guilty. The second part is where they determine if the individual is deserving of the death penalty or not. And in these kinds of cases, there are certain circumstances that come up. And most people probably have heard of mitigating circumstances, but the other one is aggravating circumstances. And so obviously aggravating circumstances are more offensive to the public. These are things like child murder or murder of a police officer, or these things that rile up people. Those are aggravating circumstances and tend to lead to a death sentence in these jurisdictions where it is allowed. Mitigating circumstances are ways in which the individual is less culpable of the crime. So maybe they weren't in their right mind space. Maybe it was an accident that led to murder, and they don't really deserve to be killed themselves because it was an accident. Like, mitigating circumstances are always things that are trying to say, yes, it happened, but do they deserve the punishment that is technically supposed to be for this? Probably not. All right. Another thing that can happen, other than a hung jury and bifurcated sentencing with a jury when a death penalty is involved, is something called jury nullification. And this is when the jury itself, like the group, decides that they have an issue with either the substance, the administration of the law, or the sentence that's imposed by the law. So they have an issue with something in the letter of the law that's going on. And so what they can do is, by nullifying the jury, they can acquit an individual despite evidence that says, yeah, they should go to jail. So it's just important to note that that is an option. Obviously, after a trial is completed, there's post-trial motions. These tend to be retrial in like all cases. Then is the sentencing part, which in most jurisdictions, the judge is in charge of imposing criminal sentences. And so here's something that might be new to you. Our text does talk about it's pre-sentencing investigation. And this is where an investigation is done, usually by some kind of probation officer, where they put together a report that collects the convicteds, educational information, employment record, criminal history, the present offense, prospects for rehabilitation, and personal issues like addiction and things like that. What they do is a pre-sentencing investigation report will look at all of these factors and go, here are my recommendations for an appropriate sentence for this crime that they are being sentenced for. And so obviously the judge makes the decision in most of these jurisdictions, but they can use that pre-sentencing investigation to guide how they plan to go. Other ways of sentencing are obviously victim impact statements, which are pretty straightforward, but this is, the victims of the crime or the family of the victims of the crime. They get a chance to put forward what they think is fair. It's often, if it's not part of a defense during the trial, or not a defense, part of a witness statement or anything like that during a trial, it tends to be read at the sentencing. So, that kind of thing happens. There's such a thing as a sentencing hearing where the prosecutor recommends a sentence or supports recommendations based off of the pre-sentence investigation report. But in these sentence hearings, usually the defendants have the right to make a statement to the judge before the sentence is officially handed down. The idea here is that due to your own personal plea, the sentence might be lesser. And so now we get to talk about terms that are pretty self-explanatory, but if you've watched any like murder trials or really, really bad trials, like the Epstein case years ago, concurrent versus consecutive sentences. Concurrent sentences just means they're all served at the same time. So you may get, grand total if you were consecutive would be like 300, 400 years. But if you do them all at the same time, it might be, only 80 years, that kind of thing. Yeah. Obviously, a consecutive sentence is you finish one, on to the next one. Concurrent just means they go at the same time. And so it should be obvious by this point, but if not, a sentence is definition-wise, a punishment ordered by the court for a convicted defendant. And so now we do need to talk a little bit about the type of sentences that an individual can receive. And to make it easy for me and hopefully clear for you, I am going to just type out all of them in a list here real quick. And hopefully that helps. So, all right. So we have death penalty. We have incarceration. We have probation. We have intensive supervision probation. We have boot camps. We have house arrest and electronic. Nope. ELECTRONIC monitoring. We have fines. We have restitution. We have scarlet letter punishments. And we have asset forfeiture. And I definitely need to. There we go. Oh gosh, what happened? Sorry, I gotta fix some of my weird errors. Okay, so these are the types of sentences that our textbook puts forward, and I just want to kind of touch on some of these, specifically ones that might not be familiar. Death penalty, I think, is pretty familiar to most people, as well as incarceration. Death penalty, person is able to be put to death or life imprisonment if something changes. Incarceration is they're simply, removed from society and put in a place like a prison. Probation, the idea is that you can return to society supervised and with limitations, and if you break those rules, you go to prison, so you do get incarcerated. But this is one that, gets a little bit different. Intensive supervision probation is more intense and typically has some kind of rehabilitation component with it. So there is this idea that it is probation, but it's a little more micromanaged. You're going to be watched a lot more. You're going to have more limits put on you, things like that. Boot camps tend to be for juveniles, but this is pretty much following the militaristic style. And the idea is that environment teaches discipline and accountability. However, much like Scared Straight and other things, the research shows that it has a little impact on recidivism. So, yeah. House arrest and electronic monitoring is a subset of probation. Obviously, house arrest, for anyone that's not familiar, is the concept that, you are allowed to not be in prison, but you have to stay within a certain confines of your house. More modern wise, yes, you are stuck to your house, or maybe like a 30-foot radius outside of your house. Like, there are limits to it. In the old days, there was a little bit more freedom of house arrest, quote unquote. But with the rise in electric monitoring, it's made it easier to do that. The classic, I got the monitoring thing on my ankle, the ankle monitor. That's that kind of concept. Real important, though, about house arrest, it was actually a federal experimental program in relation to probation and trying to lessen the number of people incarcerated. And it was successful because in 1991, they expanded it from an experimental project to a larger scale thing. And now it is used, and there are rules as well as sanctions like fines and community service. Because, community service is something, and oh my gosh, I can't believe I forgot community service. Look at that. I'm glad I said that. So obviously, as I said, with the house arrest, there tends to be other things like fines and community service. These are straightforward. Fines are money that you give to the state for your particular crime. Now, one thing I do want to emphasize is that some jurisdictions use a sliding scale based off of your income, and these are called day fines. Because it wouldn't be fair if, a $200 fine for someone who makes decent money is a drop in the bucket. But $200 for someone who's struggling to pay for groceries and drive to work and things like that, that's impossible. And so they really some jurisdictions try to be fair. Community service is pretty straightforward. This is the, clean up trash on the highway kind of thing. Restitution is similar to fines, except you're paying money to the victims rather than to the state. There's some different implications with that. I want to talk about asset forfeiture first. That's where the government seizes property and assets that were used in the criminal enterprise. They can be used as evidence, as well as, you don't get it back when you're done. All right. Scarlet letter punishments. These are controversial. And the reason they're controversial is data doesn't show that it works, but at the same time, it could work and it could be useful, and it's a weird thing. So a scarlet letter punishment, if you're not familiar, the Scarlet Letter was an American novel about a woman who was caught cheating on her husband with a man, and she was forced to have a red A pinned to her outfit at all times to show the entire village that she lived in that she was an adulterer, that she committed adultery. Long story short, the guy she cheated on with her husband with was, oh God, I think it was a minister or something. I don't remember all the details, but he refused to do it. But she took the Scarlet Letter, and it's a whole thing. But the idea behind a Scarlet Letter punishment is that you are shaming the individual for committing that crime. And so this is where issues of cruel and unusual punishment, this is where, it doesn't really affect crime or recidivism. It doesn't change things. It's not really a punishment. There's a million possible arguments for it. And so I think it's just important to note that it was and kind of is a thing. But I ask you, is it cruel and unusual, or one or the other? Is it constitutional to shame an individual for their potential crime? Just something to think about. All right. And then in 1984, we got the Sentencing Reform Act, which was there needed to be fairness in federal sentencing practices, which meant that, we have to look at and consider precedent. And so something that came from this Sentencing Reform Act is that there really are, with sentencing, particular incarceration and probation, a lot of these that have a time associated with them, not necessarily the ones like fines and restitution and stuff like that, but the ones that are related to a time, so incarceration, probation, intensive supervision, things like that. With sentencing, they needed to have fair practices, and so they came up with three kind of breakdowns, and our chapter does talk about those breakdowns a little bit, and so I'm just going to actually jump right to it. I guess I have to go to the bottom of the page. Sorry. And so there are indeterminate sentences, determinate sentences, and mandatory sentences. Those are the three distinctions. Indeterminate sentencing, indeterminate means that there is no set end time. And so really in criminal sentencing, an indeterminate sentencing means that there is not a set time period. So really the time served is based on the individual's conduct while they're incarcerated. This is really where, if good behavior is observed constantly, you can take it to the parole board and then you could be released, quote unquote, early. But yeah, indeterminate just means that there has never been a stated, you must attend this much time in prison, or attend is the wrong word. You are sentenced to this much time in prison. Determinate sentencing is there is a fixed length. There is a beginning and an end. Typically, they are not reviewed by a parole board. However, sometimes, good activity. What do I use? Good behavior. Sometimes good behavior can reduce the sentence a little bit, but typically the parole board's not going to say, "Oh yeah, they're rehabilitated. They can return to society." They don't hear those cases. Whereas indeterminate will be like, "Yeah, based off of what you've done and everything like that, you're free to go." And then mandatory sentencing is a little bit different. This is where there's a minimum. You have to do the absolute minimum, but after that, it becomes an indeterminate where, based off of good work and stuff that you've done, you can get out. So these are the three basic breakdowns of what that Sentencing Act really did. Yeah. All right. I think I tried to make this lecture as quick as possible, despite being a long chapter. So if something didn't make sense, okay, I did spell forfeiture right. Sorry. But if something didn't make sense or you didn't hear me clearly, please send me an email. Let me know what wasn't clear, what you have questions on regarding this week's information. I'll be glad to go over it, either one-on-one or make a text post about it. It won't be through Whiteboard, I promise. But yeah, that's the notes. I powered through. Hopefully you did too. Anyway, make sure you do your discussion board post as well as your quiz for this week. And next week will be our last week of textbook content. And then we're diving into our last week of special topics, as well as wrapping up things with our final exam. All right. Stay healthy, stay classy, and I'll talk to you all soon.